language speaks for itself. Include sufficient information to support the allegations. That also kind of gets into the basis claim. But again, we're at a very narrow, very low burden of proof level here. And I would call your attention in that regard to, I believe it's paragraphs 5 and 6. If the board would take a couple seconds to read through it. So there certainly are at least allegations. I would note that there's 3 different violations of the code that are alleged. One of them, questions of impartiality. They're bound to uphold and carry out efficiently and impartially the laws of the state of Wisconsin. Again, we're not saying that that has happened right now. We have to consider whether it's alleged and whether there's support. That the respondents knowingly disclosed and permitted the disclosure of confidential information, and they attempted to use their public influence to gain advantage for City of Philippi. So those are, I think those are the 3 charges. I don't know, any other board members come up with any actual charges?
That's all I see.
Okay. The name and address of and position of the individuals in the complaint. Facts constituting violations, we just went through that. And the complainant believes the board member has a bias. I didn't see a statement of bias on here. When you guys read through, did you see anything that says the person's bias? Or do you believe that the statement that there's no one, that they didn't act impartially is an indication of bias? What do you guys think?
I think that's the implication.
Yeah, because there's nothing that specifically states that, but that's a reasonable reading of 34-4. Also, there is, of course, as I noted before, there is a September 7, 2018 response. The dates become kind of important because in order to maintain our competency, our right to go forward under the law, they should have been served in the order stated. So we probably should go through and kind of note, the affidavit kind of does it for us. The complaints filed with the clerk, as far as we can see, that must have been August 1, right? Is that what you said? No, that's when they met. What's the affidavit say? August 22nd, there you go. Forwarded to corp, it was the corp counsel that actually did the filing. And again, that would have been the 22nd. The complaint was served on the complainant and the respondents and the board members also on the 22nd. So the 22nd is our start date, obviously. Joint response was filed on September 7th. That would 10 business days. I think we're probably still okay. I'd have to go through the calendar. But
Starting on the 22nd.
you count it, starting on the 23rd and include the last
Is that just business days or is that total days?
That's business days.
What about holidays?
Holidays would not be included, legal counting.
And to the 7th?
Yeah. you include the
I
7,
meant 12 days.
at 12 days. The
In between.
The filing of the complaint actually wouldn't impact our jurisdiction, and we would have the ability to simply, the filing of the response arguably doesn't affect our ability to go forward.
Wouldn't we be counting from the date of receipt by then?
No, yeah, what is the date of receipt?
1 on the 24th and 2 on the 25th.
Okay. So if we went from the 24th, we're already there, right? Yeah, it doesn't clearly say that.
We would be at 10 days, starting on the 27th.
And in any case, I would recommend to the committee that they simply accept the answer. It's a good faith answer filed before we met. So, and it also helps us frame the issues. And then, let's see, what else do we have here? There's a response, copy sent to board members and respondents, and then the agenda for the hearing was filed and posted, and the hearing's within that 25 days from the initial receipt, which I think the dates bear out. We're here on the 19th, and the initial receipt was the 22nd plus 10 business days plus 15 days. So, based on that, with the possible exception of the response, which I think we should waive, it appears we have jurisdiction. And then looking at the listed things that are supposed to be in the complaint, it appears we have all those. Does anybody have any observations to the contrary?
I have none.
With that, I think it would be appropriate for the commission, the board, to make a motion finding jurisdiction. There's two motions you could make. If we didn't think we had jurisdiction, I had it written out too. But if we believe we have jurisdiction, a motion to the effect that, based on the verified authenticated affidavit of Diane Hyder, the Board of Ethics finds that it has jurisdiction to proceed on the complaint by supervisor, the complaint of, what's the title? Complaint of ethics code violation by Supervisor Francis Dunlow and Supervisor Art Wong. And that all elements of the complaint are present. If everybody's satisfied that that's the
I'll
way
make
it
a
is.
motion that the committee has jurisdiction over the complaint and the answer.
I'll second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? That motion carries.
Our next step then is to look at whether there is a basis in the complaint for, I want to read it exactly the way it says it, so we have our, first of all, we assume that every allegation is true, and we have to determine whether the complaint alleges facts that provide a reasonable basis to constitute a violation of the Code of Ethics, or that an investigation of possible violation is warranted. So that would be how we should look at the complaint and look at those allegations and make that determination. It's probably a good idea for us to just look through it and talk it over a little. It should be mentioned that paragraphs 1, 2, 3, 4, and 5, I believe, are all admitted in the response. So kind of the fact basis, that background stuff, is agreed to in the response. Nope, I misspoke. 6 is definitely not if I said that. And 5C is not agreed to. So those are an issue. And then 6. But other than that, those first ones, the ones that kind of set up the factual basis, appear not to be in dispute.
Any initial thoughts here?
Well, the initial thought is we're just looking at the complaint, not the response.
Correct.
If you just
Correct.
look at the complaint, 1, 2, 3, and 4 are admitted, so there's no dispute about that. But if you look at 5C, which is contested, it alleges facts which form a basis for the complaint, even though it's denied. D, 6 is denied, even though it alleges a basis for the complaint, and 8 and 9 allege a basis for it, even though they are denied. So the question isn't whether they're denied or whether they're contested, the question is there a basis, and I think there is a basis in the complaint for that.
Yeah, I think the heart of the basis in the allegations is 6. Because it goes, that really talks not just about what provisions were violated, but why.
Yep.
And that's basically that they disclose something from a public meeting, they disclose the allegations of.
From a closed session.
Closed session, I'm
Right.
sorry. Probably wouldn't have been as bad. Disclose details of confidential investigation supporting allegations, and stated their personal opinions in attempting to sway others' perceptions and judgments. Again, at this stage, we take those allegations as true. There may be defenses to all this, and that would be part of what you would you would review before you make a probable cause determination, if there's evidence, certain defenses or other things that you think may affect those. But right now, we're just looking at what the complaint says and seeing it's true.
I would agree.
So is there any dispute that there's a basis in the complaint, assuming everything in the complaint is true?
That's your issue. And if you're satisfied that there is, I'd entertain a motion to that effect. Something, the allegations of the complaint are true. All the requirements of 3410 of the complaint are fulfilled. That's the basic things that it's in writing and so forth. Paragraphs 6, 7, 8, and 9 of the complaint each provide a reasonable basis to constitute violations of the Code of Ethics. That's basically what we need to find. And I guess that is encompassed by saying there's a reasonable basis in the complaint. The other thing is we can look at each of the allegations. If we think some are and some aren't, we can pull out ones if you don't think they're appropriate. You should be aware of that before you make your determination.
I think maybe we should look at each one.
Okay. I agree with you. I think we really should. So, and 7, 8, and 9 allege the ethics violations. Carry out and impartially, efficiently and impartially all laws of the United States. Bound to uphold and carry out efficiently and impartially all laws of the United States, state of Wisconsin. Based on what's alleged here, do you think there's a basis for making that determination?
Yes.
I think maybe we ought to back up to 6.
Okay.
6B. Now, I understand that they're alleged for having discussed, disclosed the allegations against the subject in closed session. But the Friday prior to this letter coming out, wasn't our county manager on TV talking about the same thing?
And you're getting into a defense now, but that's a valid thing that if we investigate, we should look into. Right now, we just take this as being fact. You know, we're stuck with it, if you will.
Okay.
But that certainly is something that would be relevant. You would probably want me to look into in the investigation phase.
I think all that 7 is saying is that a violation, there was a violation of the ethics code. And we take this as fact that this did happen. I think there's no dispute on 7.
Yeah, I agree with that. I don't think there's any dispute about it.
Well, you probably want to move on to 8.
When you're looking at 8, again, you're not looking at whether it's disputed or not, you're looking about whether it is forms the basis for the complaint.
That's correct.
I don't think there's any question that it forms the basis for it, even though it's contested.
And then 9, using public influence to gain advantage from this by. Is there something stated here that would form a basis for that conclusion?
I would say that exists simply by the content of the letter.
If the letter hadn't been attached, you'd have to wonder who Cindy Flippy was, because she's
Right.
not otherwise identified in the complaint. Once the letter is attached, that's the identification that forms a basis for that.
So we need a motion to move on then, or?
Yeah, a motion to determine that the complaint states a basis for a violation of the ethics code would be in order. And if you want to be more specific, like call out the paragraph you can.
Motion if there's a basis for it, I guess. Is that right?
And
So the motion is motion basis.
Go forward.
Assuming all the allegations to be true, the verified complaint alleges facts that provide a reasonable basis to constitute the violation of the ethics code.
Okay.
That's how you so moved.
So moved.